Yesterday, we talked about a major win for the Second Amendment in the 11th Circuit Court of Appeals out of Florida, where they vacated an order that actually upheld Florida's 18 to 20-year-old gun-related ban. I'm going to show you how this has a positive ripple effect all across America, specifically in something that just took place in Colorado in a lawsuit challenging a Colorado gun control law. Stay tuned. We're going to talk all about it. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gunner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Disarm: What the Ukraine War Teaches Americans About the Right to Bear Arms. We always want to learn from the mistakes and lessons of others, and that's why I wrote the book about the Ukraine war, to teach us about the importance of the right to bear arms all across the world, especially here in the United States, where we never want to lose that fundamental right. And don't forget to follow me on Twitter at @4boxesdiner if you're on Twitter. All right, folks. Breaking news here out of the state of Colorado. Just to jog your memory, earlier in the year of our Lord 2023, this year, the governor, Jared Polis, signed a law that prevented 18 to 20-year-olds from being able to acquire firearms. Now, this is supposedly to help out and stop crime because younger people are more inclined to engage in crime than older people. Of course, no discussion of how this is somehow going to impact the gangbangers that don't follow the gun control laws in Colorado. Nor does it discuss, of course, the fact that many 18 to 20-year-olds, including, let's say, young female nurses working late at a hospital on a shift, how they're able to protect themselves if they can't acquire firearms to protect their lives when they go into the workforce, when they come back. And as you know, younger people often don't have as much money as older people. And that's because younger people haven't worked as long as older people in their lives. So they haven't had the opportunity to save money, build assets, and so on. So younger people in some ways are at greater risk of violent crime than anyone else. And yet here you have the state of Colorado has banned the ability of 18 to 20-year-olds from being able to acquire, specifically purchase firearms. Now, the good news is the Rocky Mountain Gun Owners organization has sued earlier this year to try to enjoin this law. Now, the reason why I'm bringing this up in connection with what just happened in Florida. Let me connect a couple dots for you, and then let me tell you why this is good news. Remember, I've talked about on this channel the importance of legal precedents. As you know, I've tried to teach you that every time there's a Second Amendment victory, whether it be in a federal court, a state court, a law passed, whatever it is, that is another brick. Every legal precedent, everything in our favor is another brick that you add on brick upon brick upon brick, meaning legal precedent about legal precedent upon legal precedent, to build a wall surrounding and protecting our right to keep and bear arms, which of course is a pre-existing right. Now I bring this up to say that when we have a major victory in a court case, other courts and other litigants supporting the Second Amendment can use that. And that just happened here and right now. Specifically, as you recall, on Friday, the United States Court of Appeals for the 11th Circuit, based in Florida, covering Georgia and Alabama as well, vacated a 3-judge panel ruling that had upheld Florida's ban on 18 to 20-year-olds acquiring certain firearms. Now, this was vacated by the 11th Circuit Court of Appeals because they've decided to hear the question presented whether 18 to 20-year-olds have a right to keep and bear arms. They've decided to hear that question in that case out of Florida called National Rifle Association versus Bondi en banc, which means the entire 11th Circuit is going to hear that case. It's pretty clear to me that they're going to achieve the right answer, which is a pretty obvious answer as I see it, that 18 to 20-year-olds have a clear right to keep and bear arms just like any other adult. I think that is a slam dunk case. And whenever you see courts ruling the opposite way, it's pretty frankly goofy and clearly wrong historically and beyond. And usually outcome-oriented judges are doing this. They hate guns. That's my opinion. That's how I see it. So I bring this up because you have this pending case in the federal court, the federal district court there in Colorado, brought by several plaintiffs, including the Rocky Mountain Gun Owners Organization, represented by attorney Barry Arrington, who has handled a lot of major Second Amendment cases across the country. I'm sure you've heard the name before. So there's a pending motion for an injunction seeking to enjoin this law passed by Colorado, infringing upon 18 to 20-year-olds' right to keep and bear arms. And I think that's a motion that should ultimately prevail, and it's a case that ultimately prevail, but one doesn't know how these lower court, inferior court judges ultimately rule. But what's interesting is that the motion for an injunction had been largely briefed by the parties. And of course, the state of Colorado, in defending this gun control law, relied heavily on the 3-judge panel decision by the 11th Circuit a couple months ago that said, out of that Florida case, that 18 to 20-year-olds did not have a right to keep and bear arms for all intents and purposes. So Colorado, using that 11th Circuit panel decision, argued that, hey, the 11th Circuit agrees with our view. But I told you right from the start when that 11th Circuit case came out that it was silly, and I couldn't believe it was going to withstand any scrutiny and would likely get kicked to the curb. And that has just occurred. Because again, on Friday, the full 11th Circuit came out and vacated that decision, which makes that precedent no longer a precedent. Now, the reason why I put that into context is, guess what happened? Well, the Rocky Mountain Gun Owners Association just filed what's known as a Notice of Supplemental Authority with the Federal District Court there in Colorado, announcing exactly what I just said, which is that the 11th Circuit has vacated that major bit of alleged legal authority that Colorado was relying on to defend their law. Specifically, the Rocky Mountain Gun Owners Association filed this and said the following, quote, on July 14, 2023, the United States Court of Appeals for the 11th Circuit issued an order vacating, which means kicking to the curb, vacating the panel decision in NRA versus Bondi, 11th Circuit 2023. The order vacating the panel decision is attached. The vacated panel decision in Bondi is the primary authority upon which the state of Colorado relied on its response in opposition to plaintiff's motion for a preliminary injunction. A vacated opinion is void and thus has no legal effect whatsoever, and it cites certain cases. I would go one step further and say the fact that the 11th Circuit en banc decided to vacate the 3-judge panel decision is strong evidence that the 11th Circuit Court of Appeals is going to rule against the state, which other courts of appeals have done in the past, most recently the 4th Circuit, in a case that was ultimately moot because the people that won the case had turned 21, and therefore the case became moot because, again, they were now 21, the law didn't apply, but there's already a powerful decision by the 4th Circuit Court of Appeals out of Virginia and Maryland that says that indeed 18 and 20-year-olds have the right to keep and bear arms, which of course they do for many reasons. I'll just remind you that when the Second Amendment was adopted in 1791, and of course it says the right of the people to keep and bear arms shall not be infringed. So the question about 18 to 20-year-olds, are they part of the people? Well, the answer is pretty simply thus. To begin with, as you know, under the Bruen methodology, and because this is not a gun ban case, it's not an arms ban case, you don't have to apply the Heller test of in common use, so you go through what's known as the Bruen methodology, which you start with the text and you go to the history, which, as you know, is really the Bruen test, except elaborated on in Bruen. Heller set forth the text and history test, but because courts screwed that up, the Bruen case came along and basically elaborated on it and made it easier to understand, supposedly for the lower courts. So the Bruen methodology is really the Heller methodology, but now it's called the Bruen methodology, but they're basically one and the same. And the way that works, of course, is you look at the text of the Second Amendment that reads, the right of the people to keep and bear arms shall not be infringed. The question, obviously, is who are the people? And in this case, the Supreme Court has repeatedly said that basically all American citizens are the people at the textual level. Now, once all Americans are the people at the textual level, if you have a gun control law that impacts any part of the people, in this case, 18 to 20-year-olds are not allowed to be able to purchase guns in the state of Colorado. Obviously, a part of the people are now having their Second Amendment rights infringed or touched upon at the textual level. At that point, the burden shifts. I repeat, the burden shifts to the government. And what does the burden to the government do? The government then has the burden to come forward to demonstrate that the law that they've enacted, in this case, Colorado saying 18 to 20-year-olds cannot buy guns, cannot acquire guns. I'll post to the relevant stuff in the link down below if you want to look at the details. Basically, in light of that, the government of Colorado has to come forth and show that this ban on 18 to 20-year-olds acquiring guns or purchasing guns is somehow long-standing in American history, going back to the time of the founding. Now, of course, this does go back to the founding because, as we've talked about this repeatedly, and as I've discussed in my articles, including in the Harvard Journal of Law and Public Policy, if you're trying to interpret the words of the Second Amendment or any aspect of the Bill of Rights, which were enacted in 1791, you need to go to look at the understanding of those words in 1791 by the people that ratified and effected it, meaning the original public understanding of those words in 1791, because that was who was adopting it. It's no different that if you and I sign a contract today, to understand what that contract means, we would look at what happened and what we thought today, not what people think about the contract 200 years from now, because they're not binding to the contract. So here, of course, the question is, what did the Second Amendment mean in 1791? It obviously means that 18 to 20-year-olds have the right to keep and bear arms, and I'll tell you why in a second. First of all the people are covered, but then you go to the burden shifts to, again, the burden then shifts to the government to show that they're not covered. They have to somehow show that 18 to 20-year-olds, there's some law in 1791 that 18 and 20-year-olds can have guns, but they simply cannot do that for multiple reasons. I think the best evidence and the best of this is the Militia Act of 1792, which said that all 18 to 45-year-old able-bodied white males had to bring their own firearms and weapons and ammo to militia musters. And of course, how is an 18 to 20-year-old within that group of 18 to 45-year-old men, how isn't any of those men able to acquire firearms if they don't, and bring it to militia musters if they cannot privately acquire them first and foremost? Because again, they had to bring their own guns with them to militia musters, their own ammo with them to militia musters, which is not a big deal because people were able to, of course, acquire these firearms, and they had a right to do so. And by the way, the only way, of course, you can exercise your right to keep, which means to possess, and your right to bear, which means to carry firearms, is you have to be able to, first and foremost, acquire them, because even when we're born, we're not born with guns in our hands. So therefore, the only way to use and effectuate a right to keep and bear arms is to go out and acquire them by usually purchasing them, although we could also make them, but that's a separate video and a separate legal question. But yeah, you can make your own guns, but certainly you can buy your own guns, because otherwise there's no way to effectuate your right to keep and bear arms. So anyway, so the fact that 18 to 20-year-olds are being prevented from purchasing firearms in Colorado obviously implicates the Second Amendment, and there's no history here. In fact, the history goes just the opposite way in 1792, because of course you had to bring your own commonly owned guns, which means, of course, you had the right to acquire them at the age of 18 to 20. Beyond that, keep in mind, if you look at the text of the Constitution itself, we don't always talk about the entire Constitution, but sometimes we do. If you look at the text of the entire Constitution, there are multiple examples of when our founding fathers wanted to add age restrictions, they knew how to do it. So, for example, you have to be 25 years of age to sit and run for the House of Representatives, meaning the Congress. You have to be 30 years of age to run for the United States Senate, and you have to be 35 years of age to become and run for the presidency. These are age requirements in the Constitution itself, right? So the question is, do you see any kind of age restrictions, age qualifications in the Second Amendment's right of the people to keep and bear arms? The answer is obviously not. Even though the founders know how to write in age restrictions because they did it for the House, the Senate, and the White House, being the presidency, they did not do it in the Second Amendment. And that's further powerful evidence that 18 to 20-year-olds obviously have the right to keep and bear arms. But remember, none of this matters because the burden is on the government to show, Colorado has to show that in 1791, at the time of our founding, when the Second Amendment was adopted, that 18 to 20-year-olds were not able to buy guns. There literally were laws on the books that said that 18 to 20-year-olds could not buy guns. So the fact that they can't find any that speaks to this issue, any persuasive ones at all, that alone means that we win. But then when you throw on the fact that the Militia Act of 1792 requiring 18 to 20-year-olds to bring their own guns to militia muster, those are their own guns, I repeat, and the fact that the Founding Fathers knew how to write age restrictions into the Constitution if they wanted to do it, and they didn't do it with respect to the Second Amendment, it is pretty clear here that that ultimately, I think the 11th Circuit Court of Appeals out of Florida is going to rule in our favor that 18 and 20-year-olds have full-blown Second Amendment rights. And the good news is that I think the Rocky Mountain Gun Owners Organization and their attorney, Barry Arrington, have made a wise move to submit this information to the federal district court, letting them know that this 11th Circuit panel decision that the state of Colorado was relying on is no longer good binding precedent. I think that was a smart strategic move. And the point I want to make to you today is this. when I talk about these various wins across the country, I know sometimes we get a little depressed with all the media hype and the anti-gun this and the anti-gun money and all that stuff. But I'm telling you, bit by bit, one by one, these precedents that may not sound like a big deal in any one day or any one jurisdiction, it has a ripple effect where other lawyers and judges can rely on it to advance the Second Amendment. So again, when you have a win in the 11th Circuit on a Friday, you can see on a Saturday other people are using that win to advance our right to keep and bear arms. And in this example, in the state of Colorado, and that is exactly how we in the Second Amendment community should be doing that. We should all be relying on each other and supporting each other and encouraging each other, because any win that someone has in a random state thousands of miles away from where you might live has a ripple effect that can be favorable to you and vice versa. We must always remember that we're all in this together, because as Benjamin Franklin famously said after the signing of the Declaration of Independence, we must all hang together or we most assuredly will hang apart. Okay, with that said, make sure you subscribe to the Four Boxes Diner and learn a lot more about the American Constitution and American history. And if you haven't subscribed to me on Twitter at Four Boxes Diner or here on YouTube, please do so. We're really trying to continue to grow this channel as best as we can. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.